If you're facing an Article 120 UCMJ allegation, then you need to understand something very important. These cases are often defensible. My name is Michael Waddington. I'm a civilian military defense lawyer with the firm of Gonzalez-Waddington. I've been a military defense lawyer and civilian defense counsel for over 25 years, defending service members around the world in court-martial cases and military criminal investigations involving sexual assault. I've handled all sorts of cases from murder, war crimes, sexual assault, sexual harassment, white-collar crimes, but a bulk of my cases are military sexual assault cases. So let's talk about some common defenses to Article 120 UCMJ cases. One of the biggest misconceptions about military sexual assault cases is that the government automatically wins, that you have to prove your innocence. That is not true. The burden of proof is on the government. They must prove each and every charge, each and every element of every charge beyond a reasonable doubt. The burden never shifts. A strong court-martial defense often begins with understanding the actual facts, understanding the law, and not buying into the emotional accusation. You have to remain objective if you're going to defend these cases effectively. So what are some of the defenses? One of the most common defenses that we see and that we use often is consent. It's a simple defense, and it's something that should be raised if the evidence supports it. In many Article 120 UCMJ cases, the encounter was initially consensual, and often it remained consensual. But sometimes, for various reasons, there's often regret, there's shame, there's other factors that pop up. And what ends up happening is the alleged victim starts reframing and reinterpreting the sexual acts, what actually happened. They start going through it in their head. They start talking about it, thinking about it, telling people about it. And many times the person who's involved in making the allegation is in a relationship. They're married. They don't want to be looked at as someone who's promiscuous. Sometimes they're embarrassed. They're shamed. Maybe they hooked up with a person that all their friends thinks is gross and they couldn't understand why, or they cheated, or they're getting peer pressured, or sometimes even the command gets involved and you have sappers and SARCs and victim advocates trying to tell the person that they think they've been sexually assaulted, which ends up leading to sometimes a court-martial. So in my opinion, text messages are some of the best evidence in these cases. Now, clearly, if the messages are incriminating, they're not going to help you, right? If you're over there apologizing for a bunch of crimes you committed and admitting that you did it, that's something we're going to have to deal with. But often what we see is not that. What we see is we have flirtatious texts. We have messages where they're discussing future sexual activity, what they plan on doing in the future. Often we have messages after the alleged assault that are affectionate, they're normal. They don't show fear. They don't show anything abnormal. Sometimes they're sending of sexual photos and messages back and forth during and after, if it's an ongoing alleged assault. These are all things that are relevant to us. Another example is requests to meet up again, discussing what happened, and there's no mention of any crime, continued sexual conversations, sexting that goes on after the fact, or any other behavior that can contradict claims of fear, abuse, or trauma. So that encompasses a massive area of potential messages. If we have messages that can show that there was no fear, there was no trauma, that the alleged victim wanted to continue the relationship, that wanted more sexual relationships or hookups or meetings or just even a dating relationship, that can go a long way in proving consent and mistake of fact as to consent. So in a trial, you have to preserve this evidence if you have it, recover it if you can, and use it effectively. Now, the government's going to try to shut it down a lot of times and not let you use it because they're trying to win in most cases. No matter what the facts are, they're trying to win based on my experience. And so you have to know how to effectively use these messages. That's why a skilled, experienced civilian military defense counsel can really help you out in a case like this if they are truly experienced in Article 120 UCMJ cases. If they're not, then they're not probably going to be as helpful as someone who's done hundreds of these. Another issue that we see in these cases is alcohol involvement, like people are drinking. Very common thing in these cases. I would say, in my experience, about half of the military sexual assault allegations that we are involved in involve some form of alcohol and drinking. To the government, oh, alcohol is involved, you can't consent. They'll argue, if you had a couple drinks or one drink, you can't consent. That is not the law. You cannot let them get away with arguing things like that, or you're going to be in trouble. The issue is not whether alcohol was involved. Alcohol is commonly involved in adult behavior and even in adult sexual behavior. The question really is, was the person involved in the encounter capable of consenting? Because there's a huge difference between being intoxicated. One drink will make you intoxicated to some level, whether you like it or not. Scientifically, if you're drinking one drink, it's going to have some physiological effect on your body. That's not the question. The question is the person legally incapable of making a decision and consenting? Do they understand where they are, what's happening, what's being done to them, what they're doing? And this distinction becomes very critical at a court-martial. A lot of people don't know how to defend blackout cases. They don't know how to defend intoxication cases. And they kind of go through it very haphazardly. But you have to apply science, apply common sense, and apply a system and expert witnesses if necessary. You have to be able to attack the amount of alcohol, the ability to consent, and do that on cross-examination of the government's experts. My wife and I, who's my law partner, Alexandra, we've written multiple books on cross-examination. I wrote a book on closing arguments. It's called Kick-Ass Closings. And we teach around the country how to cross-examine effectively expert witnesses, forensic psychologists, toxicologists, and people like that. And I've written extensively on the topic. So if we were to be involved in your case, we wouldn't be reinventing the wheel or learning this for the first time. We literally have several books on this topic that lawyers around the country use. So another issue that comes up in these cases is an issue that comes up in every sexual assault case is credibility. And inconsistencies exist in every case. How you highlight that and how you maintain your credibility while eroding the credibility of the accuser and of the witnesses testifying against you, whether it's law enforcement or experts, requires a tremendous amount of skill, planning, and knowledge of how jurors interpret your questions and who you are. And now, if you come across as a very aggressive, over-the-top, rude, demeaning lawyer, you're losing credibility immediately for you and for your client. In these cases, credibility matters. There can be inconsistencies, but if you have no credibility, meaning the jury doesn't think that you're credible and you're truthful and they don't like you, then those inconsistencies might not matter. I hear this all the time. People say, we had all these inconsistencies, and I went in there and I attacked the victim and I attacked the experts and I attacked the cops, and we lost. I don't know what happened. Well, because the jury didn't like you, they didn't trust you, and they hated you. And you speak for your client. So if they hate you and they don't trust you, then you look like a dirtbag speaking on behalf of someone who's probably what? A dirtbag. Your client could be 100% innocent, but you can literally ruin the case as a criminal defense lawyer if you handle the case incorrectly, if you go in there guns a-blazing, attacking everyone, objecting to everything, being rude and disrespectful to everyone. And you might think you're scoring points, but you're not. You must be calm. You must be professional when dealing with a military sexual assault case because you must maintain your credibility. You can easily show that you know what you're talking about, that you are prepared, that you are a master of the science, for example, pass out intoxication, without yelling at people, without shaming people and being obnoxious and rude. You should not do any of those things. Being obnoxious and rude is a sign of weakness, and jurors hate it. So if you have credibility, then you move on to showing the inconsistencies. And you need a timeline. A timeline is crucial. I tell people this all the time. I need a timeline. I need a detailed timeline. From the moment you all met until the last communication that you had, I need to know details of what happened, where it happened, when it happened, how it happened, messages, and I need to back that up because in a sexual assault case, the timeline is crucial. It's one of the most important things. We also look at whether the story evolved over time, and that, again, ties into the timeline. You don't have a timeline. All you have is a bunch of vague statements, and you don't know how to plug them in, and they don't mean anything unless they're plugged into the timeline. You have to look at what witnesses were involved in influencing the alleged victim. The timeline, here we go, back to that. Was CID or NCIS or OSI involved? When did they get involved? What friends or what SAPper, what VA talked to the person? Did their story change after that? Obviously, stories are not going to remain exactly consistent, so you have to target big inconsistencies, ones that matter. You attack every inconsistency, and you look like you're just flailing around. You also have to ask what details were added later. Again, you need the timeline. Because if they were added later and you don't know when they were added and how they were added and what was exactly added, then you're just confusing the jury. If you don't have this squared away, the jury's not going to understand what you're talking about. They only get to hear this story one time. They try to get it right that first time, but they're sitting there listening to testimony one time. You've been studying it for months as the lawyer or as the accused. And if you don't understand it going into your trial, how the heck are you going to make a jury understand any of this? How they can understand what the inconsistency was, why it's relevant? You need a timeline. And it should be an actual inconsistency. And then you have to look at physical, forensic, and scientific evidence. A lot of times, the physical evidence or the lack thereof, it isn't simply evidence that exists, it's evidence that should exist. So, for example, if someone allegedly was assaulted and beat up, and then the next morning or the next day, there are no injuries, no marks, that doesn't mean they weren't beat up, but it cuts against their story. If someone was allegedly pinned down and held down over a 10-minute struggle and there's not a shred of DNA that should be there, that's one of the main things we do is we attack not only what was there or deal with what law enforcement did collect, we look at what they should have done, what they didn't do, what they did do, and what it did not yield. So, for example, if they do a whole swab and there's no DNA there, that cuts against often the theory. Then we obviously embrace physical, forensic, and scientific evidence that does support our theory. These are all factors that we consider, and we must fit them in the timeline. Another thing we hit on is in bias. This is a huge part of our defense. People don't think about it. They like to go with consent, lack of consent, mistake of fact. A biased investigation and biased investigators, they touch the entire case. They can taint the entire case. If investigators didn't do their job, if they were biased, they rushed to conclusions, they tried to force an outcome, they ignored evidence that shows your innocence, that is something you can attack in a case. That's an actual defense. It's the reasonable doubt defense. If they didn't do their job properly and they weren't thorough and they weren't complete and they weren't unbiased, then an innocent person could go to jail. That's a whole nother series of defenses and layers of a defense that you could raise by attacking what they could have done, what they should have done, what they didn't do, and why. As you can see, this gets a little bit complicated. So if you go in with a very simplistic mindset, maybe you haven't been defending sexual assault cases for a long time or never done many, you look at it very simply like, oh, this is mistake of fact, this is consent. You can go at it from many different angles and have multiple layers of a defense. So if you don't get the jury on the mistake of fact, they're not sold, but then they hear, wait a minute, the investigator didn't interview 5 of the most important witnesses. They didn't find DNA or they didn't test it or the victim deleted the phone and the law enforcement didn't recover the phone. Man, that goes to a biased investigation. That's a whole different chunk of defense you can win a case on despite the rest of the evidence. Another angle we attack is motive in bias. Motive to fabricate, motive to exaggerate, motive to even push the scales of justice in your favor and shade the evidence in a certain way. We look at often relationships. Again, they got to fit in with the timeline. Breakups, jealousy, career concerns. Was the person cheating? Was someone suspecting someone else of cheating? Were they afraid of getting in trouble? Were they looking for revenge? Were they mentally ill? Did they have like borderline personality disorder? Were they a sociopath or a narcissistic person looking for revenge, like an ex-girlfriend, a jaded ex-lover? All these things tie into a whole nother cluster of defenses. We'll just call it the motive defense. If you have a motive, you are given a lot of leeway in the military justice system in a case involving Article 120 UCMJ sexual assault, because motive evidence can come in under many circumstances where it couldn't otherwise come in, including hearsay evidence. If it goes to someone's motive, depending on why you're offering it, you can often get in hearsay evidence and other pieces of evidence under the Rule 608C of the Military Rules of Evidence. So that being said, your lawyer needs to really master and know the rules of evidence. Just not memorize the rule itself, but know all the exceptions, know all the ways to use it, because the rules of evidence are tools. There are main tools as a criminal defense lawyer. Cross-examination is a tool. Opening and closing is a tool that we use as criminal defense lawyers. But they all rely on the rules of evidence. If you are not a master of the military rules of evidence, you're going to be floundering and you're not going to really know how to fully utilize the evidence and the facts if you don't have that tool set. The bottom line is the rules of evidence are our toolkit. You got to master it. A civilian military defense lawyer who has been doing this for years should be very good with the rules of evidence, should know them, should be a master of the rules of evidence. Now, going back to the motive, that is one angle of attack that can really gain you a lot of yards. It fits into the stories that we hear as children growing up in movies, like that person who has a motive to lie, so they went and they sought revenge. The juries might not understand these little intricacies of mistake of fact as to consent and what the law says and all the nuances. But surely every juror knows lying, cheating, revenge, jealousy. Those are major themes that can be a major part of a case. If the jury latches onto that and I think that person's a cheater and they didn't want to get caught, or they cheated and they don't want to get caught, or they're lying, those are things that we can all relate to. Regardless of your education, of your rank, we all know someone who's a liar, a cheater, a manipulator, someone who would go and lie to protect themselves, someone who would accuse someone like an ex-boyfriend for revenge. We all know of those people or have seen them in the movies at a minimum or on TV, right? Jurors in the military really latch on to motive evidence. Now, going back to what I said about reasonable doubt and attacking investigators, the main issue there is that they get this tunnel vision, right? They get a case and they start by believing, they believe whatever they're being told, and it's always what the alleged victim and victim's lawyers telling them. And now the victim's lawyer is often helping the victim hide evidence, sometimes fabricate evidence. I've seen it. I think when they sit down with him and they cherry pick evidence and take him out of context, that crosses the line, but they get away with it all the time. Some of these lawyers that I run into in these cases, you cannot have your client, especially if it's a victim, deleting evidence, withholding evidence, and it happens almost in every single case. So as a defense lawyer, you need to know how to attack and expose when that happens. Because if you don't, you're leaving a lot on the table. I mean, that could win your case right there. If investigators went in with good faith, right? You don't have to always attack the investigators. If they went in trying to get evidence, trying to find the truth, and the victim's lawyer decide out of 1,000 messages to only hand over 5, 6, 7, or 8, or 9, or even 20 or 50, and they won't let them look at the phone, that is a major part of a defense. And so attacking investigators, you do it if you have to and the evidence supports it and you can. Otherwise, embrace the investigator. One technique we use is, hey, CID came in here, their hands were tied. Why were their hands tied? They wanted to get in as much evidence as possible to get to the jury, you tell the jury. And what did they do? They interviewed her. They interviewed the victim for 3 hours. But that victim showed up with a lawyer. And the victim showed up with a lawyer, not to just make sure the victim wasn't bullied, but notice the breaks that the victim took in her interview. She took 3 breaks. Every time they asked her for evidence, she took a break, came back. They asked her for her phone. She left the room. We don't know what was said, but she came back, and the investigator who's trying to get to the truth was told, I'm sorry, she's not going to provide those messages at this point. And then they continued on with the story. And then later, the investigator said, hey, do you mind if we check out your phone for a forensic examination, at least for the photos? And then the victim left the room and came back after talking to a lawyer. And then she says, no, I'm going to show you what I think you need to know, investigator. And then you argue, if you are trying to get justice and you're trying to get the truth to come out, why would you need to go out and talk to a lawyer, first of all, and then come back in and then deny the investigator who's looking for the truth the evidence that the investigator needs to do their job? How can you ever have a complete and thorough investigation if that happens? I mean, that's just one angle to go. I'm just talking to you about defenses. Now, the other thing you can do is obviously attack them. Incomplete investigations, failure to preserve evidence, failure to interview favorable witnesses, selective interpretation of text, or you can hit them with double barrel shotgun and show that the investigators went out and they tried to do the right thing, or so it appeared. They asked for the messages. The victim said no. The victim refused to hand over a calendar, cell phone data, certain piece of evidence, and then turn it on the government as well and say, this investigator's job is not to just take whatever the victim gives them, right? Their job is justice, a thorough, unbiased investigation. They made a decision to not get a subpoena. They could have easily gotten a subpoena for her phone and searched it. They could have easily gotten a subpoena for the evidence. They could have easily done all these things. Just because she said, I don't want you seeing my phone, why wouldn't you take the extra 20 minutes and get a warrant for that phone and be like, you know what? I think that's a crucial piece of evidence. If what you're saying is true, I want to see it. But they never do. So you show like not only did they start off one way, the victim shut them down and then they just threw up their hands for whatever reason. And that often is very persuasive with the juries. They often present evidence in sexual assault cases in the military. They'll present forensic psychologists to talk about victim behavior. They'll present DNA experts who always, no matter what the DNA shows, will try to imply that it shows guilt. They'll present a SAN examiner. That's a sexual assault nurse examiner. Very common in military sexual assault, Article 120 UCMJ cases. A sexual assault nurse examiner or a sexual assault forensic examiner, they'll bring someone like that in and be like, oh, I found injuries, therefore that's consistent with rape. And if they don't find injuries, guess what? That's consistent with rape because injuries heal so fast. I mean, I've heard every explanation under the sun as to when they find injuries, what it means, it's always guilt. If they don't find injuries, what it means, it's always guilt. And so you need a civilian military defense counsel, preferably, to go in and cross-examine these types of experts and expose them because they will get up there and get away with as much lying and exaggerating and misstating the science as you let them. The problem is a lot of the free military lawyers that are appointed don't know this because they're young. Many of these lawyers I work with are very good people, like the TDS, ADCs, but they're very young. Even the most eager, the top of their class lawyers, they don't have 20, 25 years of experience doing this. So you really can't compare experience level. They can be great lawyers based on their age and experience, but a military defense lawyer who's been doing military sexual assault cases for 25 years and studying this and sharpening the blade for that long is going to be a much better lawyer at cross-examining and have much more depth than someone who is a year or two out of law school. So it's better to have them team up. You get an experienced civilian military defense counsel, team up with a motivated, skilled defense counsel in the military, like a TDS, ADC, DSO, and then you get often a better result. Now, no result is guaranteed, obviously. I'm not implying that it is. But you need to know how to take down these experts. You need to know how to cross-examine them, because otherwise you're going to just get manhandled in there by government experts saying whatever they want. You literally need to go in with the textbooks, with the articles, with the knowledge and the science, almost memorized and ready to go to expose them or keep them in check. Otherwise, you can end up in jail for a crime. You'll be sitting in Fort Leavenworth for a crime you didn't commit. Jurors, they need to see these people get exposed. Otherwise, they'll believe what they're told because they're not experts either, right? Well, last thing I want to mention, silence is not proof of guilt. A lot of people, they think they have to testify. If you're going to testify, and if you can, I would seriously consider it. Talk to your lawyer about it. Can't tell you whether to do it or not, but I am pretty aggressive with putting up my clients if they can testify truthfully and survive cross-examination. I've taught many courses around the country on surviving cross, on prepping your client for cross-examination. But at the same time, if you do it right in many cases, you don't need to testify to win your sexual assault case. Often what boxes us in is our clients go in and they think they need to explain everything to investigators. They make a ton of statements before talking to a military defense counsel or a civilian defense counsel, and they've really boxed us in, right? If that's the case, then you need to seriously consider the damage that's been done and how you can dig yourself out of that going into your case and discuss at a minimum whether you should or shouldn't testify, what the pros and cons are. Because if you can testify and you get up there and your testimony is clean, it's clear, it's consistent, that it can be very powerful evidence, especially in a case of Article 120 UCMJ, where it's kind of a he said, she said, there isn't a lot of physical forensic evidence, and the alleged victim has credibility problems. It can often tilt the scales of justice in your favor and bring you much closer to a not guilty verdict. Again, no guarantees. You need to talk to your lawyer about it and seriously consider it. If your lawyer does not even consider it, I would ask why. Ask your lawyer why, okay? Why don't you think that's a case? And before you hire a lawyer, I would discuss that as well. Do you ever put your clients up? If the lawyer says, I never put a client up on the witness stand ever in my 20 years of experience, and they're dealing with military people, that would raise some eyebrows for me. It's raised a red flag because in the civilian side, a lot of people that are on trial have a lengthy rap sheet. In the military, none of my clients have a rap sheet. Most of them have never even been accused of a crime in their life. So they're like pure in a way, and it makes it a lot easier to put them up and testify if that's possible. So I would think about that. Here's the bottom line. If you're in a situation where you're under investigation, you're facing a board, you're facing a court martial, or God forbid, you're facing an Article 120 UCMJ allegation, give us a call. We do free consultations. There's no obligation. You could talk to one of us at my firm. My firm is Gonzalez-Waddington. It consists of my wife and I. We've been married going on 28 years. We've been law partners since 2006. I was a former JAG. She was a former public defender. So we've both been defending cases well over 25 years. Our firm has been defending service members for decades, worldwide. We've done hundreds of Article 120 UCMJ cases. We've done hundreds of court-martial cases, many investigations involving sexual assault. I can't even count. It's probably in the thousands. And I've done many administrative separation boards and BOIs for Article 120 cases. So if you're facing allegations, reach out. We do the free consultation. Our phone number is 1-800-921-8607. You can check us out at ucmjdefense.com. Make sure you vet a military defense lawyer before you hire them. Just don't hire the first person you see. Do some homework because it's very important. If you put your money and your life in the wrong hands, it could end up being catastrophic for you. Again, there are no guarantees, but I will tell you this. Your odds of winning your case go up substantially the more dedicated, experienced, and professional your lawyer is. If you get someone who's half-assing it, who's not a true professional, who's just doing cases there and dabbling in this, your chances go down considerably, especially in a military sexual assault case. So reach out, schedule a consultation. This is Michael Waddington. I wish you the best of luck for your case, and please like and subscribe if you like our content.